Let me tell you a little bit about how animal welfare laws got started. The man with the big idea. Hi, I'm Carly, and welcome back to the Animal Rights Tour. The most widely known animal welfare law was passed in England in 1822, and it is known as Martin's Law, after Richard Martin, who introduced it into the British House of Commons. But in fact, things had started long before that, in Ireland in 1635, so we'll come back to Martin's Law next time. In Ireland in 1635, a law was passed that made it illegal to attach a plough to a horse's, rather than a harness, tail, because it was deemed a barbarous custom, or to pull the wool off a living sheep because of the cruelty used. Much later, in 1781, a law was passed in England which made it a crime to set dogs on cattle. And in 1821, the state of Maine in the USA made it an offense to cruelly beat any horse or cattle. These laws were the beginnings of making animal cruelty illegal, meaning a person would be punished if they did any of these things. We don't know why these laws were passed, whether these practices were common or rare, and how many people were convicted. But in 1809, a law was proposed in the British House of Lords, and we know exactly why. The man who proposed it was Lord Erskine, who was then Lord Chief Justice. His law was intended to prevent malicious and excessive cruelty to animals. His arguments were straightforward. While animals were subject to human use and control, to dominion, our control should not be abused by cruel and oppressive treatment. It would be unjust and immoral, but also harden the heart against the natural feelings of humanity. In other words, not only would it be an unreasonable exercise of our ownership of animals if we were cruel to them, but it would also make us harder as people. It would diminish our humanity. Lord Erskine's proposal did not become law, but 15 years later, another law was proposed that did become law. That was Martin's Law, and we'll take a look at that next time on the Animal Rights Tour.